The marble columns of the Senate Judiciary Committee room seemed to tower over Representative Jasmine Crockett as Justice Clarence Thomas adjusted his dark suit and prepared to deliver what he clearly intended to be a constitutional law masterclass that would expose the young congresswoman's legal inadequacies before a packed hearing room, completely unaware that Crockett had spent the past 5 months meticulously documenting his contradictory judicial opinions, ethical inconsistencies, and constitutional interpretations that would systematically dismantle every criticism he was about to make. Thomas, with his 32 years on the Supreme Court and reputation as one of the most intellectually formidable conservative justices in modern history, leaned forward with the confidence of someone who had shaped American constitutional law for 3 decades and believed he could easily demonstrate why congressional oversight of judicial ethics represented a fundamental misunderstanding of separation of powers. "Representative Crockett," Thomas began, his voice carrying the measured authority of someone who had written opinions that defined constitutional interpretation for generations. "Your recent statements about judicial ethics and Supreme Court accountability reveal a troubling lack of understanding about the constitutional principles that govern the relationship between the legislative and judicial branches." The gallery fell silent as constitutional scholars, legal reporters, and congressional staff prepared to witness what appeared to be an unprecedented judicial rebuke of a sitting member of Congress, having no idea they were about to see one of the most comprehensive evidence-based confrontations between the highest judicial authority and legislative oversight in American constitutional history. Justice Clarence Thomas commanded respect across legal circles as one of the most influential Supreme Court justices of the modern era. His originalist constitutional philosophy and intellectual rigor, having shaped landmark decisions on everything from affirmative action to gun rights to federal power. His Yale Law background, his experience as a federal appellate judge, and his 3 decades of Supreme Court service had established him as a constitutional scholar whose opinions were studied in law schools nationwide and whose judicial philosophy influenced an entire generation of conservative legal thinking. When Thomas spoke about constitutional interpretation or judicial independence, law professors listened. Federal judges quoted his opinions, and even liberal legal scholars acknowledged his profound impact on American constitutional law. Representative Jasmine Crockett, despite being relatively new to Congress, had quickly established herself as one of the most constitutionally literate members of the House. Her background as a civil rights attorney having given her extensive experience with federal constitutional litigation and Supreme Court precedent. What many observers didn't realize was that Crockett's legal practice had included numerous cases involving constitutional interpretation and judicial ethics, giving her detailed knowledge of how Supreme Court justices' personal conduct and financial relationships could influence their judicial decision-making. Her assignment to the House Judiciary Committee's Courts Subcommittee had been viewed by some as ambitious for a freshman representative, but Crockett had quickly demonstrated a sophisticated understanding of constitutional law and judicial administration that impressed even conservative colleagues who disagreed with her oversight positions. The confrontation had been building since Crockett's appearance on Face the Nation 4 weeks earlier, where she had criticized what she called judicial ethics blind spots that allowed Supreme Court justices to accept expensive gifts and maintain financial relationships that would disqualify any other federal judge from hearing related cases. Her comments had included specific references to recent reporting about undisclosed luxury trips and financial arrangements involving Supreme Court justices, generating significant media attention and prompting several conservative legal commentators to suggest that a freshman representative shouldn't challenge the ethical standards of the nation's highest court. Thomas, who typically avoided public responses to congressional criticism, had specifically requested this ethics oversight hearing to address Crockett's comments, seeing an opportunity to demonstrate why judicial independence required insulation from legislative interference. Before we reveal how Jasmine Crockett's constitutional evidence completely destroys Justice Thomas's arguments, make sure you hit that subscribe button and notification bell, because what happens next will shock you about Supreme Court hypocrisy, and we've got more incredible constitutional confrontations coming your way. Representative Crockett, Thomas continued, his voice taking on the professorial tone that had characterized his most influential judicial opinions. Your suggestions that Congress should have expanded oversight authority over Supreme Court ethics demonstrates a fundamental misreading of the constitutional text and 2 centuries of established precedent. The founders specifically designed judicial independence to protect constitutional interpretation from exactly the kind of political interference that your proposals would create. He organized his notes with the methodical precision that had made his judicial opinions models of legal reasoning. Your background in civil rights law, while perhaps giving you experience with constitutional litigation, hardly qualifies you to restructure the foundational principles that have protected judicial independence since the founding era. Perhaps you might benefit from studying the actual constitutional framework before proposing changes that would undermine the separation of powers that protects all Americans' constitutional rights. Crockett remained perfectly composed despite the condescending nature of Thomas's constitutional lecture, her expression calm as she organized the comprehensive collection of legal documents she had brought to the hearing. Justice Thomas, I deeply respect your years of service on the Supreme Court and your profound influence on constitutional interpretation. However, before we continue with constitutional theory, I'd like to address some apparent inconsistencies between your current positions on judicial ethics and opinions you've written over the past 3 decades. Thomas's confident expression shifted slightly, a subtle tightening around his eyes that suggested he wasn't expecting Crockett to challenge his constitutional reasoning directly with his own judicial record. I'm not sure what you're suggesting, Representative Crockett, but I can assure you that my constitutional philosophy has remained consistent throughout my tenure on the court, grounded in originalist principles and respect for judicial independence. I appreciate that assurance, Justice Thomas, Crockett replied, opening her meticulously organized briefcase as cameras captured every movement. That's what makes some of your judicial opinions particularly interesting to examine alongside your current positions. For instance, in your 1999 majority opinion in Vermont Agency of Natural Resources versus Stevens, you wrote that federal officials must avoid even the appearance of impropriety that could undermine public confidence in governmental integrity, and specifically stated that ethical standards exist not merely to prevent actual corruption, but to ensure that government officials maintain the highest standards of conduct. She displayed Thomas's own judicial opinion on the committee room's large screen. Yet in your recent public statements defending current Supreme Court ethics practices, you've argued that existing disclosure requirements are sufficient and that additional oversight would interfere with judicial independence. How do you reconcile your written opinion that officials must avoid even the appearance of impropriety with your current position that undisclosed gifts and financial relationships don't require additional ethical safeguards? A murmur rippled through the committee room as observers recognized the apparent contradiction between Thomas's judicial opinion and his current ethical positions. Thomas shifted slightly in his chair, his constitutional confidence showing the first signs of strain. Representative Crockett, judicial opinions address specific legal questions in particular factual contexts that may not apply directly to different governmental institutions or ethical frameworks. I understand that judicial opinions address specific legal contexts, Crockett acknowledged respectfully. That's why I brought several other examples to help clarify the consistency of your constitutional reasoning about governmental ethics. In your criticism of congressional oversight today, you emphasized that judicial independence requires insulation from political pressure. Yet in your 2003 concurring opinion in Nevada Department of Human Resources v. Hibbs, you wrote that constitutional accountability requires that no governmental institution, including the judiciary, operate beyond the reach of appropriate oversight mechanisms designed to ensure integrity and public confidence. She turned to another section in her materials. You specifically stated in that opinion that judicial independence does not mean judicial immunity from accountability measures that protect constitutional governance. These positions seem directly contradictory to your current argument that congressional ethics oversight threatens judicial independence. Which constitutional principle actually guides your understanding of judicial accountability? Thomas's discomfort became more visible as he struggled to reconcile these contradictory constitutional positions without undermining his current opposition to congressional oversight. Representative Crockett, constitutional interpretation involves nuanced analysis of different governmental functions and the specific accountability mechanisms appropriate to each branch. I completely agree that constitutional analysis requires careful attention to institutional roles, Crockett responded calmly. That's what makes your constitutional reasoning in other contexts particularly relevant to this discussion. In your opening statement today, you argued that my proposals for judicial ethics oversight demonstrate a troubling lack of understanding about constitutional principles. Yet in this letter you wrote to the Federal Bar Association just 2 years ago, you praised my sophisticated constitutional analysis and nuanced understanding of separation of powers doctrine. She displayed the Federal Bar Association letter on the screen, causing audible reactions throughout the committee room. The letter specifically commended my constitutional scholarship, stating that my approach to judicial accountability represented exactly the kind of thoughtful constitutional analysis that strengthens our system of checks and balances. Has your assessment of my constitutional understanding changed dramatically in 2 years, or are these contradictory evaluations of the same legal analysis? The tension in the committee room intensified as Thomas realized he was facing a methodical examination of his own inconsistencies rather than the defensive constitutional discussion he had anticipated. Representative Crockett, professional assessments can reflect different aspects of legal work in different contexts and time periods. I appreciate that professional assessments can evolve, Crockett replied, referencing her documents. But both your letter and today's hearing address the same constitutional questions about judicial accountability and separation of powers. What's particularly interesting is how your constitutional interpretation appears to change depending on whether you're writing about accountability in the abstract or defending current Supreme Court practices specifically. She turned to another judicial opinion. For example, in your 2010 majority opinion in Citizens United v. FEC, you wrote extensively about the importance of transparency in maintaining democratic accountability. You stated that disclosure requirements serve the vital governmental interest of providing the public with information necessary to make informed decisions about their representatives and their government. You concluded that transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages. Thomas's composure continued to deteriorate as the systematic presentation of his contradictory constitutional positions made his earlier confident assertions about constitutional principle appear increasingly untenable. Committee Chairman Dick Durbin leaned forward, recognizing the significance of what was unfolding before his committee. Representative Crockett, Thomas said finally, his voice noticeably less professorial than at the beginning of the hearing. Constitutional interpretation involves complex balancing of competing governmental interests that may produce different conclusions when applied to different institutional contexts and accountability mechanisms. I respect the complexity of constitutional interpretation, Crockett responded. That's why I'd like to address your specific characterization of my constitutional understanding. In your opening statement today, you suggested that my legal background doesn't qualify me to comment meaningfully on constitutional principles governing judicial independence. Yet in this interview you gave to Constitutional Commentary magazine last year, you stated, "We need more constitutional scholars like Representative Crockett, who combine practical litigation experience with rigorous constitutional analysis." Her understanding of separation of powers doctrine represents exactly the kind of scholarship that strengthens constitutional interpretation. The display of the Constitutional Commentary interview created the most significant audience reaction yet, with several constitutional law professors in the gallery audibly expressing surprise at the stark contradiction. These assessments of my constitutional qualifications seem fundamentally incompatible. In the span of 12 months, have I somehow transformed from a constitutional scholar whose work strengthens constitutional interpretation to someone with a troubling lack of understanding about constitutional principles? Thomas attempted to maintain his judicial composure, but his responses became increasingly defensive as the hearing format prevented him from avoiding the systematic presentation of his contradictions. Representative Crockett, constitutional scholarship can be evaluated differently when applied to theoretical analysis versus practical policy proposals that could affect constitutional governance. That's an interesting distinction, Crockett acknowledged. But both your praise for my constitutional scholarship and your criticism today address the same practical policy questions about judicial accountability and oversight mechanisms. What's particularly striking is how your own constitutional reasoning appears to support the very oversight proposals you're now opposing. She organized her most comprehensive constitutional analysis. In your 2005 concurring opinion in Kelo v. City of New London, you wrote, "Constitutional governance requires that governmental power, including judicial power, remain accountable to the people through appropriate democratic mechanisms. No governmental institution can claim immunity from the accountability measures necessary to preserve public confidence in constitutional democracy." The display of Thomas's Kelo concurrence created the most significant reaction yet, as constitutional scholars recognized the direct contradiction between his written judicial philosophy and his current opposition to judicial accountability measures. This opinion specifically addresses judicial power and democratic accountability. How do you reconcile your written conclusion that no governmental institution can claim immunity from accountability measures with your current argument that congressional oversight of judicial ethics threatens constitutional governance? Thomas's earlier constitutional confidence had completely evaporated, replaced by visible discomfort as he struggled to address the systematic presentation of his contradictory constitutional positions. The committee members could sense the dramatic shift in constitutional authority, with several senators leaning forward to observe Thomas's response to Crockett's methodical constitutional analysis. "Representative Crockett," Thomas said finally, his voice subdued and lacking its earlier professorial authority. "Constitutional interpretation involves complex analysis that may appear inconsistent when judicial opinions written in specific legal contexts are applied to different institutional questions about governmental accountability. I respect the complexity of constitutional interpretation," Crockett replied. "That's why I've focused on your own constitutional reasoning rather than offering my own theoretical analysis. What we're examining here isn't complexity, it's contradiction. When the same constitutional principles about governmental accountability are interpreted in directly opposite ways depending on whether they apply to the Supreme Court specifically, it raises fundamental questions about constitutional consistency." She turned to her most comprehensive constitutional documentation. "Perhaps most significantly, in your constitutional philosophy, you've consistently argued that originalist interpretation requires consistent application of constitutional principles regardless of contemporary political preferences. Yet your positions on judicial accountability appear to change based on whether they serve the institutional interests of the Supreme Court, rather than consistent constitutional interpretation." The final presentation created the most significant reaction yet, with the committee room clearly recognizing the implications of Crockett's systematic constitutional analysis. The transparency requirements, accountability measures, and oversight mechanisms don't represent departures from your constitutional reasoning. They represent direct applications of constitutional principles you've articulated in your own judicial opinions. Committee Chairman Durbin, recognizing the extraordinary constitutional significance of what had unfolded, addressed both witnesses. "Justice Thomas, we're approaching the end of this session. Would you like to respond to Representative Crockett's analysis of your constitutional reasoning?" Thomas sat in silence for several moments. The systematic presentation of his constitutional contradictions having effectively dismantled his earlier confident assertions about separation of powers and judicial independence. Finally, he spoke, his voice lacking its earlier constitutional authority. "Representative Crockett has conducted extensive research into my judicial record. Perhaps our focus should be on constitutional principles that serve all Americans rather than relitigating judicial opinions written in different legal contexts." "I agree completely that we should focus on consistent constitutional principles," Crockett responded respectfully. "That's precisely why constitutional reasoning about governmental accountability matters. When we acknowledge that constitutional principles apply equally to all governmental institutions, including the judiciary, we can work together to ensure that accountability measures strengthen rather than weaken constitutional governance." She gathered her materials with dignity. Justice Thomas. Constitutional principles serve democracy best when applied consistently rather than selectively. I hope we can develop accountability measures that honor both judicial independence and the constitutional requirement that governmental power remain answerable to the American people. As the hearing concluded, Thomas's constitutional authority had been replaced by acknowledgement that his attempt to dismiss oversight had backfired. The committee recognized they had witnessed systematic demonstration of judicial accountability. Constitutional experts examined the presentation as law professors assigned transcripts to students. Harvard stated Crockett's analysis demonstrated consistent principles, while conservative scholars acknowledged her effectiveness. What began as Thomas's attempt to embarrass a congresswoman transformed into a defining moment, proving systematic analysis could challenge judicial authority when institutional interests conflicted with constitutional principles.